folks, and welcome back to Conveyancing. I hope you've had a good week. This week, as we jump into our Prezi, we are looking at seller disclosure. Now, we have quite a bit to get across for seller disclosure. As you can imagine, it is one of the more important modules that we will take in conveyancing. You'll see it spans a couple of different weeks. The key to doing this module successfully will be to keep up with your readings, split them out evenly over the 2 weeks rather than leaving it all until the second week, and also trying to organise and structure the knowledge that you're getting out of the readings, and I'll talk a little bit more about that in just a moment. Just some practical tips. So there are three main limbs to this module. Firstly, we need to look at the seller's obligations to disclose at law, under statute and under the REIQ standard form contracts. Now, I'll just give you a quick overview of each, and then we'll delve into each one in a little bit more detail. In terms of the seller's disclosure at law, the main issues to flag here are disclosures regarding defects in the title itself and disclosures regarding defects in quality of title. They're the main two issues that we'll need to get across there. In terms of statute, this is probably where we'll spend the bulk of our videos, just discussing the various different pieces of legislation that bear upon the issue of seller disclosure. There are just, it seems like a million of them. They're all important. They're all liable to come and bite your client when they least expect it if they are not compliant. And so I would recommend that you take your time with your readings here. And as I said, as I flagged earlier, it may help to create a little list of the various different pieces of legislation that bear on the issue here, that you can flick down when you're doing assignments or the take-home paper or later on in practice to consult, so that you're not having to constantly, no one wants to do rote learning, let's just face it. But the act here of summarising and getting yourself a nice handy list of the various different pieces of legislation, how they bear upon seller disclosure, what has to be done, and the consequences of failure to comply is a really neat way of providing yourself with a resource that will be useful later in the unit, but also getting a little, it's not rote learning, but it's getting more familiarity with the various different requirements under the different pieces of legislation. So I would really encourage you to go ahead and make yourself a little table. It might seem a bit laborious, but I think you'll find it's well worth the exercise. In terms of disclosure by contract, the disclosure requirements according to the REIQ standard form contracts. This stuff, compared to the legislative requirements, really seems fairly straightforward, and it's not rocket science. We don't need to spend a whole lot of time labouring this issue, but we will spend, as I said, most of our time talking about the legislative requirements for disclosure. So that is, I guess, where we're headed in this next couple of weeks, and now we can jump into disclosure at law. Okay, so the first thing I want to preface this discussion with is that the general law around issues like defects in title or defects in quality of title really tends to apply to open contracts rather than the REIQ standard terms. The REIQ contracts really tidied up this whole area significantly, and that's why we kind of start with the general law, we look at the impact of statute, and then we kind of circle the wagons back around and we look at how all of this stuff is being tidied up. So where your client is in the position of not having an REIQ contract, perhaps they've found themselves in a contractual situation through exchange of letters, or perhaps there's been a more significant purchase, sale and purchase of the house and one of the parties did not want to use the REIQ form. Either way, where you do have that open contract, then you're going to need to be very familiar with this stuff, particularly in Queensland, because quite often the buyer finds themselves in the situation where they have formed the contract and then they do their searches and then the problems crawl out of the woodwork. Where you find your client is in that situation, then if it's not an REIQ contract, as I said, then you're going to need to know the general law around this stuff. So firstly, we need to look at defects in title. The logical question here, I guess, is what is a defect in title? There's no hard and fast or bright line rule that we can use here to say, right, here is the line, everything on this side is a defect in title and everything on that side is a defect in the quality of title. It does tend to get a bit grey in the middle, but as we saw in the 8th and Merity case, young Chief Justice in Equity, as he was then, said that there's a very fine but real distinction between defects in title, which entitle rescission, and defects in quality, which don't. Okay, it's difficult to define. Usually encompasses a situation where the vendor, this is a defect in title, the vendor is unable to convey the full estate which it promised to convey to the purchaser. So it goes to the very root of the sale and purchase contract itself. If you can't actually give as seller what you are warranting to give and which forms the whole basis of the contractual relationship, then obviously that's going to give you the buyer the right to terminate. Defect in quality usually affects value rather than actual title itself, and that's where I guess at polar extremes of these two things, you can see the difference. Defect in title, the buyer's really not getting what they bargained for. Defect in quality of title, well, they're getting what they bargained for, but it's just not as bright and shiny and value laden as they thought it was. Examples of defects in title down the bottom there. So things that attach to the title: leases, mortgages, encumbrance easements, statutory charges. These things will qualify as defects in the title itself. Okay. Generally, with defects in title, the seller will be obligated to disclose pretty much everything, no matter how small. And even if the contract itself says that the buyer is going to take the property subject to defects in title that could perhaps be discovered by inspection of documents. And that's exactly what happened in the Faruqui case. In a special condition, the sale is said to be subject to entries on the registers of title. And then a general condition said that the property was going to be sold subject to any covenants, a copy of which could be inspected at the vendor's solicitor's offices, the purchaser being deemed to purchase with notice thereof, whether or not they made the inspection. Now, the problem for the seller was that there were in fact restrictive covenants on title. However, when these covenants were originally registered, a copy of the deed of the restrictive covenants had not also been lodged at the titles office. So the seller couldn't have got a copy of it. Obviously, the solicitors for the seller couldn't have produced it according to that general condition for inspection by the buyer. Nevertheless, you would have thought the seller had been pretty careful in drafting that contract, because it said that the purchaser was deemed to buy with notice of whatever defects in title there were, whether or not they'd made an inspection, and the factual scenario of the seller physically not being able to get a copy of these restrictive covenants. However, it was held that the vendor was required, nevertheless, to disclose in equity, and specific performance was refused. So if there is some knowledge of a defect in title, doesn't matter how small, like I said, you're best to advise your seller to disclose. Now, as is usually the case with general law doctrines like this that have developed over years and years, that's not as simple as things are. There are further distinctions to be made, and the further distinctions are distinctions between patent defects in title and latent defects in title. Now, I will remind you that, again, this is only going to be relevant for non-REIQ contracts. So we're looking at the situation for open contracts here. Patent defects in title are ones that are patently obvious. That's how I remember it. So if it's the kind of thing that a buyer could discover after inspecting the property themselves with ordinary care and diligence, it's probably not the kind of thing that the seller actually has to physically point out or in a contract point out, have you seen this large pipe running across the land? I mean, as I say there, obvious phenomenon that shows the land is burdened is not necessarily going to have to be something that the seller points out. It will be considered that the buyer is put on inquiry to make further searches. So, as I said, the example in the text is, if the buyer comes onto the property and sees this thumping great pipe running across the property, then they're likely going to think to themselves, I wonder what government authority has put this pipe there, and what restrictive covenants, easements, and so forth are in place to allow that pipe to run through the property like that. So these are the kinds of things that the seller doesn't have to worry about pointing out. As I say there in Yandel and Sons, the test is they have to be patent to the eye, patently obvious, okay? These kinds of things can be thrust on a buyer even without the seller having disclosed, because they're obvious, okay? Where the open contract is used, then obviously inquiries should be made prior to contract. And this is where the difficulty often arises in Queensland, because a purchaser will often come to you having already concluded the contract, and this is where you then have to start untangling things. And also the other issue is that there is no bright line between patent and latent defects and what should and shouldn't be disclosed, so it can get quite tricky. In terms of the buyer's redress, if they find themselves in that tricky situation, if the open contract has been used and the defect is a patent defect in title, then unfortunately they have taken subject to that patent defect in title, more than likely. The only way you could probably wriggle out of it is that the seller has somehow in the contract warranted to deliver title free from encumbrances, and they haven't been disclosed. If that's the situation, you might find that you're able to help your buyer out and assist them to terminate the contract, but other than that, they will find themselves in that tricky situation, as I said. Latent defects in title are of the kind, as I say there, that the buyer couldn't discover with ordinary care by inspection. The Yandel and Sons case is relevant again there, tells you why the seller really needs to disclose in this kind of situation. In all these cases of latent defect, the vendor knows what the property is and what the rights to it are. The purchaser is generally in the dark. So particularly where the purchaser can't go ahead and find these things out for themselves, they're not the kind of problem, they're not the kind of defect in title that would kind of, like the large pipe running through the land, they're not going to hit you in the eye, they're not blindingly obvious. And even more reason then for the seller to disclose. Equity is not going to enforce a claim for specific performance if the seller has not disclosed in those circumstances. As I say there's no bright lines here, and with all of the wonderful messiness of the common law and the fine distinctions between latent and patent defects in title, and when the seller actually is obliged to disclose and not disclose for open contracts, it's little wonder then that the REIQ and other real estate institutes around Australia really decided to tidy this area up. And as I said, we'll be circling the wagons back around and looking at that later. In terms of quality of title, so remember I said that defects in quality of title are those kinds of defects that mean the buyer will still be getting essentially the title that they have bargained for, but that title may not be as valuable as they thought. So you might have, for example, defective structural improvements, that's a biggie, restrictive planning requirements, road or rail requirements, resumptions and that kind of thing, contamination issues. These are all problems that will detract from the value of the property that you've purchased. Okay, in open contracts, again, nice big font so you all remember, the seller is under no obligation to disclose here. No obligation to disclose. The doctrine of caveat emptor is ripe and ready to assist the seller in these kinds of situations. Okay, so if it's something that just goes to the value rather than the actual title itself, then the seller is not obliged at common law for non-REIQ contracts to disclose. In those situations where the buyer has still gone ahead and purchased the property and the seller has kept silent, their only redress at this point will be things like the usual suspects, misrepresentation, fraudulent concealment, and again, if the seller in the contract has actually warranted that there will be no defects in the quality of title. You don't get that very often. The most reliable way to try and help a client out in these situations, a buyer client, is trying to fossick through the factual matrix and see if you can find some kind of misrepresentation. The Krakowski and Urilin's case is probably one of the more memorable cases on this point. So in that case, we had the sale and purchase of a shop that was subject to a lease. Well, the incoming buyer said that he didn't want the property unless it had a strong tenant in the shop that would anchor it and provide some decent means of income. And so the seller got a strong tenant to sign on the dotted line for a lease, showed the purchaser, here it is, this is the strong tenant that you were after. They're going to bring in around about $156,000 worth of rent per year. But what they didn't disclose was the fact that as an inducement to get this lessee into the premises, they had actually promised a few months rent free to the tenant, and they'd also promised to pay the tenant the whole $156,000 so that the tenant could fit out the shop premises and not be out of pocket. So there was this whole side deal went on that wasn't disclosed. Obviously, because it had been very important to the buyer to come into this property with a ready source of income, it would have been pretty disappointing to have the deal done and then find out the tenant didn't actually have to pay you as you thought they would have to do. There were issues of entire agreement clauses in the sale and purchase contract. So they thought really pretty much the buyer thought when they had a look at the sale and purchase contract, they had a look at the lease, they saw this is the entire agreement between us, you've disclosed the lease, okay, this must be the end of the story. The court held that to carry on in this fashion and not disclose the whole side agreement was fraudulent misrepresentation. So good old misrep can come to the rescue occasionally there if you find yourself in a non-REIQ contract situation and there has been a defect in quality of title that was not disclosed by the seller. So that's good old Krakowski. And that's disclosure at law. Okay, folks, well, we've gone over the 15-minute mark now, so we'll leave this video here and we will continue on with disclosure at law in video 2. Bye for now, guys.